Hello, good afternoon. My name is Fiona Scolding. I am chairing this seminar this afternoon called Indirect Discrimination, a powerful but underused tool in tackling discrimination in the UK. Thank you all so much for joining. Just a couple of housekeeping matters for those who've joined in the past couple of minutes. Please keep yourselves muted and your cameras off. However, we do welcome questions. Please do put your questions into the chat box at the bottom of your screen, and we will try and answer them at the end of this session. We are very lucky to be joined this afternoon by two speakers who have a great deal of experience in this area. Firstly, David Locke. David has appeared in a number of cases where issues of indirect discrimination and Article 14 of the European Convention of Human Rights, both of those kind of meld into one another when it comes to these concepts, has appeared on behalf of both claimants and also public authorities. He is the editor of the NHS Law Handbook published by LAG. All copies bought will enable David to possibly buy a pint of beer at some point in 2025. But he is probably the leading barrister in the area of health and social care in this country, and what he doesn't know about the healthcare system isn't really worth knowing. We're also joined by Alex Goodman, who has had a series of stunning successes this year, challenging various aspects of the government's policy on immigration towards those who either are here allegedly unlawfully because their claims have failed, or those who are awaiting decisions. He's just been in the High Court this week for 4 days in front of Mr. Justice Swift, arguing that the current support system for asylum seekers is in fact in breach of Article 3. Alex, again, has had a stellar career in the law, both writing various countries' constitutions and appearing in particular in respect of immigration, planning and public interest, public law perspectives, and has recently won a case about no recourse to public funds, which was all around indirect discrimination. So we're going to be hearing from him this afternoon. We're also going to be hearing from me. I do a variety of public law work, all about how you can or cannot justify indirect discrimination. So the only other housekeeping matters is to say that Landmark now has their own YouTube channel, I suspect not going viral. So if you wish onto which all these webinars are placed, so please feel free to recommend to your colleagues to watch the YouTube channel. All these videos will also be available on the resources pages of our website. So without further ado, I pass over to David, who's going to talk to us all about the concepts behind indirect discrimination. David.
Well, thank you very much, Fiona. My job over the next 15 minutes or so is to try and explain what indirect discrimination is as a starting point. Sometimes as barristers, we give ourselves nearly impossible tasks. And in one sense, explaining what indirect discrimination is straightforward. But the moment you scratch the surface of the concept, it becomes enormously complex and hence virtually impossible to do within 15 minutes in any detail. So let's start at the beginning and see how far we get. First of all, the legal prohibition on discrimination based upon certain characteristics has been part of the UK domestic and indeed EU law for a number of decades. The foreword to what possibly was the best book on equality law ever written by Karen Monaghan had a quotation as follows: "Equality," wrote Rabinder Singh QC, as he then was, some time ago, "is the neglected virtue, but it's not neglected now. At long last, we have the Equality Act 2010, which brings together many separate laws against discrimination and ties them to make a coherent whole. That is easier said than done. If equality is indeed a virtue, then it is a very complicated one." Now, those words were written by Baroness Brenda Hale. Later, of course, she became President of the Supreme Court. And the reference to the barrister there, Rabinder Singh, is a reference to the notable human rights lawyer who is now Lord Justice Singh, who sits in the Court of Appeal. And so that really explains, if they think it's complicated, it's complicated. In 2017, Lady Hale explained the purpose of discrimination in a case called Aesop and the Home Office as follows. She said, quote, "It is meant to avoid rules and practices which are not directed at or against people with a particular protected characteristic, but have the effect of putting them at a disadvantage." And therefore, that's what indirect discrimination is essentially about. It's about common rules, which when applied to someone or a group of people with protected characteristics, has the effect of putting those people at a disadvantage. Now, the Equality Act 2010 sets out a closed list of protected characteristics. There are 9 in number, and they're up on the slide, in alphabetical order: that age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. Now, the public policy justification for equality laws, what is creating a wrong, is that it's conduct which society deems to be unacceptable for both private individuals and public bodies, and it's unacceptable to treat someone less favourably than you would treat others because of a protected characteristic. So, for example, should someone be refused a job, refused to be served in a pub, or subject to any less favourable treatment just because of the colour of their skin or their racial origin, we would say that goes beyond what is acceptable and is a legal wrong. So just as we cannot drive a motor car precisely as we would like, because we have to bear in mind the rights of other people who are impacted by our driving, so discrimination laws curtail people's freedom to act in the way they would choose by preventing them treating other people unfavourably in any way if the unfavourable treatment is based on a protected characteristic. However, effective discrimination laws focus on discriminatory effects, not on the intention of the person whose conduct is being criticised. It's all about consequences, not intentions. And that's why indirect discrimination is both so important and also so complex. Indirect discrimination is concerned with rules, practices, policies, or other provisions which on their face apply to everybody equally, but which in practice have a differential impact on different groups of people. And it's been part of both domestic and EU law for quite a long time. The first legislative definition of indirect discrimination was contained probably in the Sex Discrimination Act 1975, and then in the Race Relations Act 1976. And it was also defined in the EU Council Directive 1997/80/EC on the burden of proof in discrimination cases. And that said, indirect discrimination shall exist where an apparently neutral provision, criterion or practice disadvantages a substantially higher proportion of the members of one sex, unless that provision, criteria or practice is appropriate and necessary and can be justified by objective factors unrelated to sex. This introduced the term an apparently neutral provision, criteria or practice. And the provision, criteria or practice, or the PCP as it's generally known, and the concept also of disproportionate group disadvantage. Let's look how this works in practice. It's shown by a very recent case involving a rule which required all Greek police officers to be a minimum of 1.7 meters tall, that is 5'7" in old money. And it applied equally on its face to all applicants. But the Greek police force was sued by Ms. Kalerati, who decided that who was rejected, and she was rejected because she was just under 5'7", and she said that it was indirect discrimination on the basis that women are generally shorter than men, and so this universal height requirement indirectly disadvantaged women. And this was, as is often the case in direct discrimination, a victory for the little person against the system, in this case, literally. So for the purpose of UK law, the primary definition of indirect discrimination is now in Section 19 of the Equality Act, which provides that there are 8 protected characteristics that are relevant. The one which is missing from the general list is pregnancy and maternity, and of course that can be indirect sex discrimination, but it's also provided for separately in Section 17 and 18 of the Act. So an act of indirect discrimination occurs where there is a provision, criteria or practice, a PCP, which is alleged to be discriminatory. Now, a provision generally means a rule which can be part of a statutory scheme or can be a different set of rules. A criterion is an overlapping concept. It's a set of standards or an established practice. And then a practice is something that is a formal or informal way of doing things in a particular environment. And the code of practice suggests these should be widely interpreted. So they're overlapping concepts and they're widely interpreted. And in the case of Isola versus Transport for London, the court had to consider what needs to happen in order for a practice to be established. And what the court decided is there had to be some form of continuum. There had to be something which said that's the way generally things are done. It doesn't mean that the PCP or the practice has to be applied to everybody. It just needs to be not an individual practice which only applies to the claimant in question. Now, once there has been this general approach which applies to a class of people, the next thing that needs to be identified in order to establish indirect discrimination is under Section 19(2)(a), which is that the alleged discriminator, applies or would apply it being the PCP, to persons with whom B, the alleged victim, does not share the characteristic. Now, this part of the test is concerned with establishing that the PCP, the provision, criteria or practice, is applied to others and not just B. The test is whether the alleged discriminator applies or would apply the PCP to persons with whom the claimed discrimination does not share the protected characteristics. Because if the alleged discriminator only applies the PCT to persons who share the protected characteristic, then that's direct discrimination because you're treating people in different ways. So, for example, if a barman refused to serve anyone who was more than 6 foot tall because he claimed he was worried that such a person would cause trouble, but in fact he only applied that rule to black customers, then this would be direct discrimination against black customers because it was applying a rule that didn't apply to anybody else. If he applied the rule to all customers, that is black customers and any other race of customers, then the test in Section 19(2)(a) would be satisfied because he was applying the criteria to people who don't share the characteristic. Then arguably it may be sex discrimination for the same reasons as in the police case. Now, the wording is important. It's not necessary to show that A has in fact applied the PCP to anybody else. It's only necessary to show that if the same facts arose in respect of somebody who did not share the protected characteristics, A would apply the same approach, the same PCP. And clearly, the more established the PCP is, the easier it is to show that it will be applied to others. The second element of the definition is in Section 19(2)(b), namely, and this may be the crucial point, that the application of the PCP, the IT, puts or would put persons with whom B shares the characteristic at a particular disadvantage when compared with persons with whom B does not share it. Hence, the question for the court is whether the application of the rule or the practice to everybody puts a cohort of people, puts persons in the plural, who share relevant protected characteristics at a particular disadvantage. And the relevant group here are the persons who share the relevant protected characteristic and those who don't share the relevant protected characteristic. And section 23(1 provides that in that comparison, there must be no other material difference between them. It's important to note, as the Supreme Court did in the case of Aesop, that none of the various definitions of indirect discrimination in both EU and domestic law is there any requirement to explain why a particular PCP puts one group at a disadvantage when compared to others. In order to establish a case of indirect discrimination, it's enough to show simply that the PCP does put one group at a disadvantage when compared to the others. The question of why it does and what the consequences may be relevant to justification, but it's not relevant to establishing the indirect discrimination in the first place. Further, the definition of indirect discrimination does not require the applicant to prove the causal link between the less favourable treatment and the protected characteristic. Instead, it requires a causal link between the PCP and the disadvantage, the particular disadvantage suffered by the group and the individual. It's thus not necessary to show that the PCP, for example, unfairly impacts on those with protected characteristic because of their protected characteristic, but only in practice this is the effect. The reason for that is that indirect discrimination is about dealing with hidden barriers which may well be not easy to spot or even anticipate. A third factor is there may be a huge variety of what are called context factors, which mean that the application of the PCP in the real world context in which people live their lives will result in a disadvantage for those with a protected characteristic, even if this was not intended or foreseen. Hence, for example, it's still the case that the vast majority of caring responsibilities fall on women in our society, and thus the refusal to allow a worker to adjust shift patterns to meet caring responsibilities will impact more on women than on men. That doesn't mean all women have caring responsibilities or no men have caring responsibilities. This is an area of law where statistical evidence is admissible to show how a PCP will impact on the way that people in fact live their lives. And that leads to the next feature, which makes indirect discrimination a bit complex, namely that it's not necessary to show that every member of the group share the particular characteristic that create the disadvantage. In other words, if proportionately more women are carers, a PCP that disadvantages carers will amount to indirect discrimination against women, even though many women may not be carers. The group will collectively be at a disadvantage if the proportion of its members of that group who can satisfy the PCP is lower than the proportion of non-members of the group who can satisfy the PCP. And again, this is an area where in practice, the key evidence is statistical evidence. Now, the third element of the test, once you've shown that comparing one group with another group, those with a particular characteristic are at a disadvantage, is that the practice in fact puts the individual claimant at that disadvantage. And here the analysis moves from the group to the individual. Hence, if the rules on setting shift patterns, which are a PCP, put carers at a disadvantage, and that amounts to indirect discrimination because more women are carers, a woman can only bring a claim of indirect discrimination if she is in fact a carer. The fact that other women who are carers are put at disadvantage does not mean that an individual who is subject to the same rules but is not a carer suffers indirect discrimination. So how does this work in practice? I'm going to give two very short examples in order to show how this works. First of all, the well-known case arising out of pension rights. What happened was that in 2015, the government implemented large-scale changes to public sector pension schemes. In summary, these new schemes introduced a less generous benefit by, for example, moving from a pension based on a final salary to a pension based on a career average salary, and providing that pensions were started when the pensioner was older. Accumulated pension rights under existing pension schemes were broadly preserved, but for most public sector workers, we're talking about NHS workers, police officers, firefighters, judges, and so on, the old schemes were closed and the workers could only accumulate new pension rights under the 2015 schemes, which were less generous. Now, if the government applied the same rules to everybody, it's probable there would have been no discrimination. But the government decided to allow those who were approaching retirement to be able to stay in their existing pension schemes and continue to accrue new rights under those pension schemes. Now, that meant that a different set of rules applied on what pension scheme you could be a member of, depending on how close to retirement an individual was. In effect, it disproportionately favoured older workers, and thus, because this benefit was not available to younger workers, it meant they were treated less favourably. And the government accepted that this was indirect age discrimination. It ran a justification defence, and Fiona's going to talk about that in a moment, but essentially it failed. And it's just published its proposals to put this right with a price tag of £17 billion. So this is why areas of indirect discrimination can be so catastrophic for public bodies if they get them wrong. The second example I'm going to give is from a case I did last year, leading my colleague Leon Glenister. There's a particularly generous award under the police pension scheme for officers who become totally and permanently disabled as a result of their police service. And that means to such an extent they'll never work again for the rest of their working life. And these are known as Regulation 12 awards, and they can be a single tax-free payment of up to 5 years average salary. So the benefit can be a tax-free payment of up to £200,000 for an officer earning £40,000 a year. The problem was the rules provided the total and permanent disablement had to arise within 12 months of the date when the injury was received. And that rule prejudices police officers who developed mental health problems as a result of their police service in comparison to officers who had physical problems. So officers suffering, for example, from post-traumatic stress disorder often had a significant delay between the triggering event and the onset of symptoms. Once the symptoms have been triggered, they can be just as disabling as a physical condition. And disability is defined in the Equality Act as being the particular disability from which the individual suffers. And it can be unlawful to treat one group with a disability more favourably than another group with a different disability if the effects of the disability are not materially different. In this case, having to give up your police career, never being able to work again. A police officer, Mr. Broughton, who suffered delayed onset PTSD, challenged the regulations as constituting unlawful discrimination, both under domestic law and under Article 14, and permission was finally given for the challenge in the Court of Appeal, and then in effect the Secretary of State threw in the towel. Mr. Broughton got his Regulation 12 award, and the Secretary of State is in the process of reviewing the regulations with a view to removing the discrimination. And once again, that example shows that an indirect discrimination claim, in other words, the same rule applying to everybody but having differential effects and impacting and disadvantaging those with a particular characteristic, can have widespread effects, because what they effectively do is to require the government body to level up benefits if they're to be maintained for any group. So that's a very brief introduction to what indirect discrimination is, and now I'll hand over to Fiona to talk about justification.
Good afternoon, everyone. I'm here to talk about, if you get over the hurdles that David has identified, you're then into the territory where a public sector body or a public body or an employer may well be saying, well, yes, we accept that there is a disadvantage to this particular group, but we say it can be justified. And so this talk is, hold on 2 seconds, is about what justification is, when it can be used, and how it might work in practice, giving you some examples of some relatively recent cases where arguments around justification have taken up the majority of the court's time. So, an essential element of any claim for indirect discrimination is that the person who is doing the discriminating, the public sector body, I'm going to say a public sector body, it is up to them to show that the discrimination is justified. So it's not up to the individual who's bringing the case to say, and in effect say, yes, okay, we know it's been discriminatory, but this can be justified. Matters can only be justified if it can be shown to be a proportionate means of achieving a legitimate aim. So in other words, you have to demonstrate as a public sector body, firstly, that the discrimination is legitimate, it has a legitimate aim. Now, they can be quite wide, as I'm going to come on to discuss. And secondly, that the implementation of the discriminatory policy is proportionate, i.e. it is appropriate and necessary, as the courts have said. And again, that is an onerous test, which the courts will anxiously scrutinise, as they say in a number of the cases. So, practically, what happens if an indirect discrimination case is brought against you, it's sensible that you probably try and get the evidence for all the arguments. So you may well be wanting to say, well, there's no disadvantage cause, these are the reasons why, or the group, the comparator's wrong. However, you were also going to want to be saying, well, we think we can justify it by reason of this particular policy aim, and there's no other way that we can do this. So the first thing you're going to need is some kind of evidence of the reason justifying discrimination. And when I say evidence, I mean specific evidence, not merely generalisations. So if you're representing local government or central government, you're going to want the cabinet papers, I mean cabinet in respect of local government, not cabinet in respect of central government, although on some occasions you might want those, discussion papers, any written ministerial submissions. One assumes, in terms of provision, criterion and practice, that there will have been an equality impact assessment, or that the matter is so obviously potentially discriminatory that issues of equality have been discussed within the context of whether or not the policy proposal should take place. The other thing you need to be able to do is in effect show that there is no practicable or reasonable alternative. It must be noted that proportionality is what is reasonably proportionate. So you don't have to say there's absolutely nothing else we could have done. However, you do have to be able to show that the other alternatives either don't exist, have never been suggested, or are not really practicable in any realistic way. The other point I should make at this stage is just remembering the protected characteristic of disability is treated in a different way to the other protected characteristics in this respect, in that there is, under the Equality Act, a specific duty to make reasonable adjustments in the case of disability. So if you've got a claim of disability discrimination on the basis that it's indirect, say, for example, you're a school which hasn't changed its policies and procedures in respect of exclusion, despite the fact that they may well have a more disadvantageous impact on, say, for example, children with autism, who may well be more likely to physically be physical, shall we say, with other children, then you would have to demonstrate that you've undertaken reasonable adjustments in order to be able to justify your policy. So that's another part of the evidence that you have to show, i.e. we have done these following things to the policy to take account of the disproportionate impact it may well have on a particular group of people. So those are the practical issues. Turning to the next slide. Again, just to identify, the burden of proof is upon those who issue the policy, practice or criteria. And again, anxious scrutiny is what we're looking at. So looking in more detail at the two ingredients, the first one is legitimate aim, the second one is proportionality. When you're looking at both legitimate aim and proportionality, you're looking the case law in respect of indirect discrimination under the Equality Act, save for issues of employment, where there have been a number of ECJ cases, because a lot of the case law on discrimination, particularly in the context of age discrimination and employment discrimination, comes from EU directives. So you've got to be looking at EU law as well as domestic legislation in that concept. Even after Brexit, you're going to have to be looking at that. But it's identical, the test, to that brought under Article 14 of the European Convention on Human Rights. And so lots of claims in respect of indirect discrimination are also brought under Article 14. And the concepts which apply under Article 14 in terms of proportionality and legitimate aim also apply in respect of the Equality Act. So you want to be looking at cases across quite a broad spectrum. So what is a legitimate aim? Obviously, under the European Convention of Human Rights, as we know, under what's called the qualified rights, so that's Articles 8 to 11, there is in effect a checklist of roughly what the legitimate aims are. So the protection of others, the protection of public health, to give two examples from Article 8 of the European Convention. The Equality Act doesn't define what would or would not be a legitimate aim. In reality, however, the courts have found that the legitimate aim cannot be discriminatory in and of itself. So you cannot sit there and say, well, the reason that we designed this rule was to deliberately exclude women from this particular criterion and practice. Furthermore, the courts have said that the legitimate aim must be real and objective. Doesn't necessarily have to have been thought of at the time. So you don't necessarily need papers which say this is the reason that we say this, but you need to be able to have a realistic ex post facto legitimate justification. And certainly in the case of employment, cost alone cannot be a reason for discriminatory treatment. However, if you say there are other justifications, plus to do anything else would cost us an enormous amount of money, that will be able to be something which is justified. And you cannot justify something which is racially discriminatory, but then say, well, the reason that it's racially discriminatory is not because the legislation says it is, but because in practice that's the way it's applied. If in reality it's inevitable that in practice that is the way that it's applied. And that's the very well-known case of ER and the Immigration Centre at Prague. That was a situation whereby anyone who was trying to get from Prague to the UK, if you were a Roma, you were basically stopped and you weren't allowed in. And there was a policy which didn't directly say it's only Romas, but indirectly and in practical reality, that was what happened. And I know that Alex is going to talk a little bit more about that, because the NRPF case is sort of in effect treads on some of that same ground. So turning next to legitimate aim, where however a lot of individuals, where however the courts have been reluctant to identify that there have been breaches of what are plainly discriminatory policies is if it involves macroeconomic or macro social policy objectives. Now, in all cases involving those sorts of objectives, the courts will give politicians, whether that's central politicians, quangos, local government, what's sometimes called the margin of discretion or margin of appreciation. And that has been identified yet again, most recently in the Lord Chancellor and MacLeod case, which is the judges' pension discrimination. where amusingly a number of judges who've made decisions about indirect discrimination in other contexts were then claimants alleging indirect discrimination against the Lord Chancellor for the manner in which a new pension scheme was brought in. So in all of those cases, and in anything which involves spending money or spending money in a particular way, spending a lot of money in a particular way, or social policy objectives, particularly objectives which have been the subject of primary legislation, for example, state benefit changes. There's been a lot of indirect discrimination challenges around state benefit changes over the past decade, given the government's approach and changing approach, should we say developing approach to the way that benefits should be allocated, that there will be a margin of discretion given to them, i.e. we are the court, we don't really know how you balance the need to spend X on schools and Y on people who are unemployed, so we will largely leave it to the government to do so unless there is an obvious and manifest unfairness. However, that margin of appreciation can only go so far. Firstly, the courts have stressed that where there are core issues of discrimination, which have largely been found to be that which involve race, sex, and disability, then there would need to be very good reason for the government to demonstrate that the exercise of discretion has been put in place for the very reasons that David identified in his original talk, which is we should all strive within the legislation and within the policies that we promote not to discriminate, and race and sex discrimination and discrimination against disabled people is to be eradicated. So they have to be very carefully justified, but ultimately it's for the court to determine what the appropriate margin is and how great that level of scrutiny should be. Now, but what the McLeod case just says is simply saying that the aim is legitimate is only the start of the story. Not only does the public body, and this was where the government fell down in this case, find that the aim could be capable, but is then to decide whether the aim is legitimate on the facts of the case. And such an aim must be rational. So you have to go on to say, look, in the abstract, this aim is capable of being legitimate, i.e. saving money, and in reality, it is legitimate on the particular facts of the case, which is an evaluative, which involves a level of evaluative judgment making. And this is the whole point about justification, is you are in effect looking at the rights of the individual versus the rights of everyone else. And the court has to weigh in the balance whose rights predominate depending on the facts and particular context. So like with most areas of public law, context is all. Right. In cases, I should put a sort of health note here when it comes to the margin of appreciation and state benefits. Now, Alex and I have been bouncing some emails around today about how far this particular concept applies only to issues to do with state benefits and how far it applies most widely. And the Supreme Court and the European Court of Human Rights don't seem to be quite in agreement with one another about how extensive this particular test is. However, where there are cases which concern state benefits, by which I mean here largely disability, universal credit, benefit caps, etc., then the test that the European Court of Human Rights has identified is something which is manifestly without reasonable foundation. So in effect, once the government, in effect, that is a fairly low threshold for the government to be able to justify policies, because in effect, it has to be shown that the policy is manifestly without reasonable foundation. Now, that doesn't necessarily mean that you can't show that. I'm thinking of two obvious cases where that was shown. Firstly, in respect of maternity grants, where it was found that there was basically no justification at all for the reason why certain sorts of mothers got maternity grants, but other sorts of mothers didn't. And secondly, I'm thinking about the case of Matheson and the DWP, which went to the Supreme Court, which was all about disability living allowance for those who are inpatients in hospital, where the where the Supreme Court found that the removal of disability living allowance in cases where severely disabled children were very unwell in hospital was manifestly without reasonable foundation, because there wasn't really any justification whatsoever. I should say in both of those cases that the sums involved were relatively small, and the number of individuals affected were also relatively small, which I think may well have played a part in the rationale, in the unspoken rationale, should we say, in the context of both those cases. However, in a lot of cases, the need to demonstrate that the policy is manifestly without reasonable foundation has led to failure, shall we say, of the individual against state policies, largely involving limiting access to benefits. So, to give the most recent example, a case which I know is going to the Supreme Court of SC and the SSWP, this is what's known informally as the two children case. What happens is after 2017, you only get paid, if you make a claim for benefit after 2017, you only get paid universal credit, or the tax credit element of universal credit, in respect of your first two children. Now, plainly, that is likely to disadvantage those families who have larger than two children. To give an obvious example, the Haredi Jewish community, who have a religious belief which precludes the use of contraception in most cases, and therefore they will tend to have lots more children. So they will, it's an obvious example of a policy which is applied to everybody, but has a disproportionate impact upon those who have significantly larger families, potentially on the basis of their religious belief. The courts in this case, in effect, have so far refused to engage and determine that this policy is unlawful or manifestly without reasonable foundation, in effect finding in the Court of Appeal's decision last year that this issue was one of significant political controversy, as the aims of the government, however, because it was the subject of significant political controversy about the various social aims, shall we say, about the reduction of spending upon various groups and fairness between taxpayers, and in effect said there was no process of legal reasoning which could justify one view in preference to another, and that therefore the court would be very slow to displace the balance struck by Parliament. Now, it will be interesting to see what the Supreme Court says about those factors. Turning to the next slide, this now, having dealt with manifestly without reasonable foundation, and just to say that there is a European Court of Human Rights case, which is the follow-on case from the benefits cap case, which in effect tried to say that it's only historic injustices which might be covered by manifestly without reasonable foundation rather than things going forward. So, but leaving that to one side, that's yet to be tested, the limits of that within the domestic courts fully. Even if you can get over the hurdle of showing that it has a legitimate aim, you then have to demonstrate that it's proportionate. Now, the most adopted statement of how you assess proportionality in the UK courts, in the domestic courts, is currently the speech of Lord Reid in a case called Bank Mellat, which was all about the placing sanctions upon various Iranian financial institutions and whether they were or weren't proportionate. And in effect, there is a 4-stage test so that measures must be appropriate and necessary to achieve the objectives of the legislation. Where there is a choice between several appropriate measures, recourse must be had to the least onerous. So you have to do the thing which causes the least problems rather than the thing which causes the most problems, if there are a number of options available to you. The disadvantages caused must not be disproportionate to the aims pursued, i.e. the means must be justified, but the end must justify the means, in effect. That's, I think, the most easiest way for the layperson to understand that. And the intensity of the test, as I've said already, depends upon the context, as in effect, these cases are all about the balance between the rights of the many versus the rights of the few, in effect. And here is the structured analysis, which if you're bringing a case, you would hope that a judge, a tribunal or a court would follow when it's looking at whether something is or isn't proportionate. This is based upon an EU case from very many years ago called De Freitas, added to by a case in the immigration context called Huang. So in effect, it's just restating the principles I've stated in the slide before. So if you are running a case on behalf of both a claimant or a defendant, you want to probably put those, have these 4 stages, and then be able to write a couple of sentences on each saying why that is the case or why that isn't the case. However, a slight note of caution to identify in a number of cases, including Bank Mellat, there is a need for the court not to substitute its judgment. So what Lord Reid said, basing his decision upon a case in Canada, is there will very rarely be a case where a judge couldn't come up with an alternative that could have been adopted, but that isn't the test that should happen. However, there is to be a great deal of scrutiny of the issues involved. Now, a number of academics would say that what this in effect means is that proportionality is more dependent upon, shall we say, the background or attitudes potentially of the judiciary or of the member of the judiciary you happen to have on the day in question than maybe it should be. And an example of this in practice is the JFS case. Now, the JFS case was all about the admissions policy to the Jewish Free School, a very popular and highly academic secondary school in North London. JFS, like most other schools, most other Jewish schools which follow the, shall we say, the United Synagogue or more orthodox, what one might call the orthodox traditions, had a policy of giving priority to those who were considered to be Jewish under halakhic or Jewish law. And in effect, what that says is if your mother is Jewish, then you are Jewish. If your father is Jewish, you are not Jewish. Now, what that in effect meant was that various individuals who came from, shall we say, less orthodox traditions or who had converted into Judaism were not seen as being Jewish for the policy of being able to gain admittance to the school. Now, the Supreme Court found that this was direct discrimination on the grounds of ethnicity, causing, shall we say, uproar within the Jewish population of the UK, and the rabbinical authorities, both in here and in Israel, on the basis that about 3,500 years worth of tradition was being overseen. But it's a case of the Supreme Court saying, actually, we don't, even though this will be very controversial, we do think that this is directly discriminatory on the grounds of your ethnicity, being Jewish, being an ethnic, being considered to be an ethnicity for these purposes. But alongside the direct discrimination issues, there was also a discussion by most of the judges about indirect discrimination. And this is where you can most obviously see the outcome on whether the policy could or couldn't be justified, depending upon the individual judge's application of proportionality. So, for example, Lord Mance, Lady Hale and others who made up the majority looked broadly at whether the school had established that other less discriminatory alternatives were unsuitable to achieve the aim of having a school for Jewish children who followed halakhic law. So, in other words, had they thought about signing in at synagogue or having attended various courses or matters which were, shall we say, could be objectively justified to demonstrate your Judaism without simply whether or not your mother was or wasn't born a Jew. They also considered the impact on society of maintaining this discriminatory policy and whether it was right that there should be such discrimination in existence in the context of a state school. And Lord Mance and Lady Hale and others found that on that basis, looking at things broadly, the policy was not justifiable. However, Lord Roger and Lord Brown took a much narrower view, examining the needs of the school and the Jewish community and Jewish tradition, rather than the discriminatory impact it would have on individuals who did not meet halakhic law, and basically said, we think that it's not right to overturn 3,500 years of Jewish teaching and Jewish law in this respect, and that we therefore consider that the policy was justifiable. Now, this follows on to another point which I want to make, which is academics also consider that religious rights are sometimes afforded less protection than other protected characteristics. And certainly there has been cases, particularly in the EAT, particularly around discrimination, where it's almost as if you're looking at weighing which right is more important, largely the rights in respect of sexual orientation versus the right in respect of religious belief. And I certainly don't agree that the rights can be ranked in that way, because they're all protected characteristics. There aren't some protected characteristics which should be more important than the other. However, certainly in the employment context, there appears to have been such ranking taking place. So looking at a couple of examples of proportionality in practice, firstly, SG and SSWP, which is the benefits cap case. Again, this did not succeed, largely because it was all to do with macro social strategy. And even though it was absolutely clear that this policy affected women more than men, it was seen as acceptable on the basis that there was no other way, in effect, of achieving the legitimate aims other than to identify that discrimination. Another case called Gulu, which has subsequently been overturned in the Court of Appeal, but it's useful when we're looking at the sorts of issues that judges look at. So it's the judge in that case found that the policy could be justified on the basis that the allocation, this was whether or not a policy of housing allocation which required 10 years residence was indirectly discriminatory against refugees. Now, the judge got both parts of the test wrong. Firstly, who the comparator should be, and secondly, how you approach justification. But he said, in effect, well, housing stock's a matter for the local authority, and the objectives of the scheme for rational, and therefore to have a shorter waiting time would be quite wrong. Now, that's been overturned by the Court of Appeal, but it shows the approach which is taken in practice. The most recent example I could find, other than the ones that Alex has been involved with, is the Mayor of Bromley and Persons Unknown, which is all about injunctions which are brought against gypsies and travellers. In effect, what's been happening is local authorities have brought, in effect, borough-wide policies, basically saying nobody can camp anywhere in our local authority. And what this has done is this has squeezed gypsies and travellers from significant parts of the UK, because there are these wide, worldwide injunctions against anyone where you can't do that. And the judge at first instance, and it's well worth reading her judgment because it's really carefully thought through, she went through all the various factors, examined them and weighed them to see whether it was or wasn't proportionate. Now, in that case, she found that the injunction against everyone for everything was plainly disproportionate, given the wide terms of the injunction, the absence of any evidence of any criminality by those who were camping, the fact that no lesser injunction sought, for example, Bromley to say, well, look, we don't want people to camp here because of this particular problem, but they can camp here. And in effect, it was disproportionate, given the fact that it was in effect preventing gypsies and travellers the right to pursue their nomadic lifestyle, gypsies and travellers being a particular ethnic group, and therefore it was indirectly racially discriminatory against them. There was also a difficulty that Bromley had not done any equality impact assessment before applying for the injunction or seeking to enforce this practice. So that sort of gives some examples. I now turn over to Alex, who's going to give us a worked example of his recent NRPF case. Thank you, Alex.
Hello, everyone. I'm going to talk about the role the law on indirect discrimination can play in helping the UK to wake up to the continuing impact of racism on our society. In fact, confronting indirect discrimination, I would argue, is perhaps what the UK needs to do most of all. And I say this because direct discrimination is generally understood. Most people in the UK know that to refuse to interview someone of Asian background, for example, because the employer wants someone who fits in with the local population, would be to discriminate directly. Indirect discrimination refers to measures or policies which seemingly affect everyone equally and do not directly target a minority, but which have a disproportionate effect on a minority group. There is an argument that it is the greater evil than direct discrimination because it's more insidious, and by virtue of the very reason that it's hidden, it's more harmful than direct discrimination and victimization. I can hear someone else's, if they could mute, if everyone could just mute, because I can hear someone else. I hope everyone can hear me. As Black Lives Matter has revitalised the anti-racist movements in the UK, the initial focus in the UK seems to have been on cultural artefacts and the UK's legacy from imperialism. But I wonder whether as this movement matures, it may encourage more confrontations with the living legacy of the dismantling of empire. And that living legacy, I would say, is the system of immigration control that's evolved primarily since the Immigration Act 1971. And there were far more limited forms of immigration control before that time, but it's that act which has defined the UK as a country which is constitutionally discriminatory. And that's because it's a bedrock of our country's law now that people will be treated differently depending on whether they are citizens or not. And that system is both directly discriminatory in that the intention is to deliberately treat foreigners in a less favourable way. But it also has numerous ramifications into indirect discrimination, many of which are not foreseen. The many indirect impacts of immigration control on British Black and minority ethnic groups are not always properly confronted in the development of policy. So, for example, while some people of a non-British background are entitled to mainstream benefits, it's inherently more likely that people of such a background will not be entitled to such benefits as compared to white British people. And so NRPF, that's no recourse to public funds conditions, and the system around that is one example. And there's no hiding from the uncomfortable fact that these impacts, these differences in treatment are at least indirectly racially discriminatory. And indeed, discrimination on grounds of nationality, on grounds of national origin, are by definition subcategories of racial discrimination, both in the Equality Act and in Article 14. But domestically, and it's fair to say internationally, norms have emerged by which these forms of racial discrimination, essentially flowing from citizenship discrimination, are legitimated, and immigration control has become a kind of catch-all justification. But in a wider sense, and this is not a matter of legal principle, but in a wider sense, justification asserted simply because a measure forms part of what we've defined as immigration control is not really a justification at all. It's just a way of saying that we as a country have decided we're comfortable with that form of discrimination against foreigners. And we've become so used to the naturalisation of discrimination against foreigners that it's important we sometimes pause and remind ourselves that our legal system being structured in that way is one that is based on a legitimation of the indirect consequence of that, which is numerous forms of racial segregation. And rights that we enjoy in almost every aspect of our lives, whether it be access to the right to work, to healthcare, to education, to housing, to the welfare state, all of these areas contain discriminatory provisions which segregate foreigners from citizens and which then indirectly thereby contain provisions which privilege people of British ethnic backgrounds over those with different national or ethnic backgrounds, and also which inherently privilege white people over non-white people. So I'll come shortly to the, I think I'll come now to the case, because I want to say as much as I can about that. I had a few other things to say, but given the time, I'll come back to those. So I think it's helpful to emphasise the genesis of the Equality Act in understanding how we apply the provisions in it. The genesis of the Act was the Macpherson report into the murder of Stephen Lawrence, in which it was acknowledged for the first time that the Metropolitan Police suffered from what was described famously as institutional racism, a collective failure of an organisation to provide an appropriate and professional service to people because of their colour, culture or ethnic origin. And flowing from that report, it laid the foundations for the establishment of the Human Rights Act and the Race Relations Amendment Act of 2000, which introduced the race equality duty and then fed into the Equality Act 2010. And so the very genesis of a lot of the duties in the Act, particularly, for example, the Section 149 well-known duty to have due regard to the needs to eliminate discrimination and advance equality of opportunity, were the findings of the Macpherson report. And in fact, Mr. Justice Calvert-Smith commented on that fact in Haj Ruler. So race, as defined in the Equality Act 2010, includes colour, nationality, and ethnic or national origins. See Section 9. So these three aspects are protected characteristics on which the other provisions of the Equality Act then bite. Sections 19, 29, 149 can all be in play. Now, within the Equality Acts, there are then general exemptions in the schedules, which are aimed at carving out immigration control from the ambit of the non-discrimination provisions. So allowing discrimination, even forms of race discrimination within the immigration sphere, particularly Schedules 18 and 3. But this seems to me to have had an undue chilling effect. It's important, and this is really the main point I want to get across in this talk, to ensure that we interpret those provisions in the Equality Act precisely and don't assume they are broader than they are, because as Mrs. Justice Elizabeth Lang said in the case of Chirani against Secretary of State for the Home Department in 2019, EWHC 1586 at paragraph 128, she said, the mere fact of an immigration context does not attract the exemptions in Schedule 18. So Schedule 18 does contain a number of exemptions, but for example, the PSED, Public Sector Equality Duty in Section 1491B, is disapplied in relation to discrimination based on nationality or national origins. Now those are two subcategories of race discrimination. So those are disapplied, but colour is not disapplied in respect either of direct or indirect discrimination. And similarly, in Schedule 3, paragraph 17 to Part 4, that provides that Section 29 does not apply in relation to nationality or national origins to anything done by a relevant person in the exercise of functions exercisable by virtue of a relevant enactment. And basically that means that where provisions which include the immigration rules discriminate on grounds of nationality or national origins, as of course the majority of the immigration rules do, that form of discrimination is exempt from the ambit of the Equality Act. However, that exemption does not apply to discrimination on grounds of colour. And so in the case of W, which has been decided recently by the Divisional Court, it's Crown on the application of W against Secretary of State for the Home Department 2020, EWHC 1299 admin. The Divisional Court in that case quashed the scheme for imposing conditions allowing no recourse to public funds on grounds that it failed to comply with Article 3 of the European Convention on Human Rights. But further component of that challenge was not decided because it didn't need to be in the immediate circumstance in which the case arose, but is now afoot. And that was about the discriminatory impacts of the no recourse to public funds policy. And the court hasn't gone on yet to decide that. It's still before the court. Now, an earlier challenge had been settled, similar grounds, on the basis the defendant undertake a public sector equality duty review of the NRPF, the no recourse to public funds policy. That's now been completed. So W was a case, one of many that had come before Dayton Pearce Glynn, about a black British child who had a foreign mother. And his foreign mother had leave to remain on a 10-year route to settlement, but attached to her leave to remain was a condition entitling no recourse to public funds. And the data revealed in the Home Office's public sector equality duty showed that the black British children, or non-white British children, are inherently more likely than white British children to be subject to no recourse to public funds conditions. That means that those non-white British children are therefore inherently more likely to be subject to the spectrum of effects of that policy. And the evidence in the W case showed those kind of impacts included extreme poverty, street homelessness, repeated interruption of schooling, having to dislocate from communities by moving home repeatedly, living in substandard accommodation, and going without ample food and clothing and other necessities of life. And that's because if you're denied all access to the welfare state, to support yourself with young children as a single mother, as many of these were, proves very difficult, particularly with rent and all the other costs of living. And so if anyone loses their job, for example, they're normally thrust into a state of destitution. The claimant alleged that the decision in his case was indirectly discriminatory on grounds of colour. And as I've explained, race discrimination in the immigration rules is exempted in the schedules, save with regards to discrimination on grounds of colour. Now, the defendant says that this is simply an oddity and claims, I would say rather hopefully, the claimant shouldn't be able to bring challenges at all to the immigration rules on these bases. It says it's just a workaround. But it doesn't seem to me that that actually was the intention of the legislation. The carve out for discrimination on grounds of colour is not accidental. It's deliberate and in fact flows directly from the terrible circumstances of the Stephen Lawrence case. So just to explain the argument as quickly as I can, to go back to the Court of Appeal case in the Crown TW, or now known as Ward and Gulu against Hillingdon. It's in the Court of Appeal 2019. The court there sets out the right approach to following through an indirect discrimination challenge. In that case, it was all about Hillingdon's housing allocation policy, as Fiona set out, which provided that, subject to exceptions, a person who hadn't been continuously living in the borough for at least 10 years wouldn't qualify to join the housing register. And two challenges have been brought, one by gypsies, one by a recent immigrant, neither of whom could meet the criterion, and who both alleged that the criterion inherently was likely to discriminate indirectly against them. And the court found that a 10-year residence requirement to be allocated housing by the local authority did disadvantage non-UK nationals more than UK nationals, and indeed travellers more than a settled population. So if you go back to the NRPF case, what we say is that the populations, or the groups for comparative purposes, are on the one are those who share the relevant protected characteristic, being black or non-white, and those on the other hand who do not. And so the question in that case is whether non-white British children are put at a disadvantage in their access to the welfare state compared to white British children. And our argument is the answer must be yes, because the proportion of non-white British children who don't enjoy the panoply of entitlement to the welfare state because their parent has a no recourse to public funds condition is substantially greater than the proportion of white British children. And really, this could be proved by specific statistical evidence, but as the Court of Appeal says in Ward, it's just so obvious from the limited statistics available that that's the case. One doesn't really need to go further than that. And so that mere fact of differential treatment then requires justification. And the defendant says in the W case, the NRPF case, that the difference is because the claimant's mother is being treated differently, not the first claimant. So in other words, the defendant's argument is really that the impact on the British child, the black British child not getting assistance from the welfare state as he grows up and therefore living in a considerably greater degree of poverty than than he would be likely to if he were from the white British population, they say, well, that's just collateral damage because it's all about the mother's immigration status. But that defence is wrong. And that's because the reason for indirect discrimination or the cause of the differential treatment does not exempt the defendant from having to justify the indirect differential effects of the policy. And that's made very clear by Lady Hale's judgment in Essop against the Home Office in the Supreme Court, where she says, none of the various definitions of indirect discrimination, in none of them is there any express requirement for an explanation of the reasons why a PCP puts one group at a disadvantage to another. So it seems, so the burden's on the defendant to justify the indirect discrimination in issue. And in that respect, it has to satisfy the Bank-Mellat fourfold test that Fiona has just been explaining. And the Secretary of State's position is, oh, well, it's all just to do with the difference, the foreignness of the claimant's mother. But that's not a sufficient answer. And it's not for the court to search around for justifications. Courts made that point in the Elias case, 2006. And a generalised appeal to immigration control, protecting the public purse, all of that, doesn't cut the mustard. There's no dispute that discrimination against foreign children might be justified by those. But the diminution in quality of life of British children to the level of immigrants needs itself to be justified by more than a generalised reliance on immigration control. So in other words, as Lady Hale says in SG, that's the 2015 Supreme Court case, she says, it's on the benefit cap, it's not enough for the defendant to show why the NRPF policy was brought in. We can readily understand why no recourse to public funds conditions are being imposed. But the defendant has to explain why they're brought in a scheme in a way which has disproportionately adverse effects on non-white British children. So something over and above the immigration control justification has to be put forward. That's the argument. And so there seems to me to be there a decent argument on the law as to why the policy is racially discriminatory. And that's not just a point about technicalities. It's not just a technical legal argument that helps us win a case. Because what it shows is that what Theresa May called the hostile environment, and that's what the no recourse to public funds scheme came out of, that hostile environment is now ramifying, and not just in this case, into areas of policy that have racist implications, not only in the generally understood sense of that word, but potentially at least infringing the basic legal minimum standards that prohibit discriminatory conduct. And that's what this case is all about, because W and people in positions like him is a British boy, and he and many, many others like him are never leaving the UK. They're not subject to immigration control. They've got no right of citizenship to any other country. And the Secretary of State needs to explain why less intrusive measures are not being deployed, which do not ramify into implications for British citizens in what is differentially an impact of much greater impact on non-white people than white people. I'm running out of time, so I'm just going to summarise the last couple of points. There is another related point in the case, which is about Flimenos and Greece. And we say the defendant has to show why the discrimination is justified, despite the significant difference in situations of non-white British children and foreign children, why British children are disproportionately treated the same way as foreign children, and why there's no nuance or less intrusive measures for British children. The defendant's in a difficult situation because the policy equality statement produced hasn't really articulated a coherent justification other than relying on a generalised appeal to the economic interests of the country and immigration control. We also have an Article 14 ECHR ground, which I don't have, unfortunately, time to explain as well, but may well reach the same outcome as the route through the Equality Act, because, of course, like the Equality Act, Article 14 prohibits racial discrimination on grounds of national origin and on grounds of colour. And so I hope really that this case will start to expose some of the ways in which our current immigration policy is going well beyond now what can rationally and properly be described as being as impact solely on immigration, rather than what clearly I think would offend most people's sense of what's right, that these policies are now really spreading and ramifying so as to have impacts that are of a racial and colour-based nature. Thanks very much. I hope that was okay, and we've still got time for a few questions.
Well, thank you very much, Alex, for that very powerful and thought-provoking talk. And I think you've certainly convinced all of us that the Secretary of State should just give in now and not fight on. In particular, I think it's very interesting because, of course, the NRPF is just one of the series of hostile environment cases. I'm thinking that there's the case about landlords, the rules that were introduced in respect of landlords in 2015, which are currently the subject of a judicial review, at least in part on indirect discrimination grounds, because of the need to sort of look at various things, which meant in effect landlords are now saying, a bit like they used to in the old days, no blacks. It used to be no dogs, no blacks, no Irish. I think now it's no one who can't show me their immigration status, which obviously is disproportionate. And there's also other issues to do with the impact on driving licenses, because the hostile environment policy sort of spread a lot of issues to do with immigration control and to do with differential treatment into all aspects of social policy, really, didn't it, Alex? Or hasn't it, in effect?
Yes, absolutely. That's what I'm getting at.
Yeah. So, and Robin Taylor, who I think is from DPG, said, not a question, just think Alex is so on point with this. So, and I think we can probably all agree with that. Now, we have some questions. I will try and direct them to the right people. Firstly, there's a question from about legal aid, which you two won't have seen, but I've got, it was sent to me privately, saying, are discrimination claims covered by legal aid? And do you have any suggestions as to how these claims can be funded privately? Yes, discrimination claims can be funded by way of legal aid. They have to go, or certainly until very recently, they used to have to go through the helpline. There is a discrimination helpline. So they have to go through a gateway before they then get allocated, but there are specific and specific ability for legal aid to be claimed on discrimination. Furthermore, most of the matters that Alex is talking about, I suspect, are undertaken on a general public law contract, as all the issues to do with breaches of the Convention or breaches of the Equality Act could also be held to be public law wrongs. So firms which hold an individual public law contract could also obtain legal aid for that. Other than that, the Equality and Human Rights Commission obviously does fund strategic litigation. It goes through phases. Last year, it had a sort of open access policy whereby it would fund a sort of any case that walked through the door for a particular period of time if it was in a particular area where it felt that there needed to be more litigation. So one of those was education, because I know there were a number of education cases brought, and not just strategic cases, just cases about individual people. And certainly I think issues around immigration control and disproportionate race discrimination are part and parcel of their strategic plan. I think all three of us are members of the Equality and Human Rights Commission panel, And sometimes the best way to approach them is to approach one of their lawyers and tell them a little bit about the case and indicate that. Other than that, crowdfunding is the other way that I think quite a few of these cases could be funded. Certainly those cases which demonstrate the objectionability and the overt race, or the not overt, covert racism, are likely to attract funding, I would imagine. Alex, David, any other views about funding?
Well, I know that Robin Taylor has very helpfully said that the gateway has gone. I knew the gateway was controversial, shall I say, and
yes.
And that doesn't surprise me at all. We're sort of slightly away from the coalface as barristers, but yeah. Otherwise, no, I agree with you. I think there are the key challenge in any form of indirect discrimination case is to identify the difference between the cohort, the collective, the evidence that you need for the overall effect, and then before you descend to the particular. And it can be very difficult for an individual to assemble what is effectively cohort evidence, unless, you know, as in Alex's case, it's so obvious that it's difficult. The harder needs to be proven. So that's why in practice they can be difficult cases to run. Having said that, with a reasonable amount of digging, there's an awful lot of data out there, and it is possible to obtain the evidence, but it is not straightforward.
We've got a next question. I'm going to aim this at David first, from Helen John. Say, is it more difficult to obtain successful outcomes in cases involving indirect discrimination, against public bodies in employment issues, especially claimants from a BAME background? Now, none of us are employment law specialists in particular, but I'm throwing that ball in David's direction.
Is it more difficult than what? Clearly, it is easier to run an individual case based on individual facts with an individual manager who's been racist, or there's an individual act, somebody who was not given a job who is obviously more qualified than somebody who was appointed. In a sense, that's the evidence for that type of case is easier to structure, whereas indirect discrimination cases are by their nature policy challenges. So Alex's case, the two examples I gave, the various examples Fiona gave, the consequences of success tend to affect not just the claimant, but a whole bunch of other people as well. So the answer, I think, is they are potentially more difficult, but they're also potentially more beneficial if you're successful, because the effects spread much wider than the individual client for whom you're acting.
And the two obvious examples of success in those cases are actually some of the earliest, which is about head coverings in various public sector jobs and in various forms of employment. And obviously back in the 1970s, there were a series of cases about whether Sikhs could serve and perform various jobs while still wearing their turbans. Now, there would be a general rule saying no head coverings if you're performing various jobs. Now, that rule would in and of itself be neutral. However, obviously it has the indirectly discriminatory effect of meaning that no Sikhs can do the job. And certainly in a number of cases, the courts, I mean, this was back in the late 70s, early 80s, had no problems finding that those things were discriminatory. Another matter that I can obviously think which would be indirectly discriminatory would be timing meetings. So, for example, if you said we have to have a meeting every Friday at 4 o'clock, that would be indirectly discriminatory if you were an Orthodox Jew, because for at least 6 months of the year, you'd be home by Friday at 4 o'clock. Starting Shabbos preparations. So, you know, things like that, those sorts of obvious things to do with employment. I know there has been a lot of concern amongst employment lawyers that religious discrimination claims, which sometimes overlap with race discrimination claims, but don't always, have not been terribly successful in the employment tribunal, and I know that there have been problems, and I also know that the number of claimants in employment cases from a BAME background who succeed in race discrimination claims is vanishingly small. I think the reasons for that are many. So next question, Alex.
I'll just add to that. I think ESSUP in the Supreme Court is such a good case to read just generally on this topic. It's the one I'd pick out to read as the clearest exposition of the principles. And of course, that was an employment context. It was about Home Office employees having to pass a core skills assessment test, and it was being found there was an indirectly discriminatory impact of having to pass that test in order to get promotion. So yeah, just to flag that.
And that case was fascinating because that was in effect what happened in that case was that the claimant said, this is more difficult for us. And the Home Office's response was to say, well, you prove why. If you can prove why, we'll do something about it. But if you can't explain why it's more difficult, then in effect, why should we be readjusting our systems? And they won that in the Court of Appeal and lost in the Supreme Court. And they lost in the Supreme Court with the reason I was trying to make is that if the effect of a practice is discriminatory, the question as to why it happened and why that impacted on the protected characteristic and how in practice it works is actually all part of the justification question. It's not part of the is there indirect discrimination in the first place question. And that's why, again, that case is worth reading because it very clearly identifies the difference between the two. And as Fiona said, whereas the claimants have the onus of proof of showing there is discrimination, once you prove discrimination, the onus of proof changes and the duty to lead evidence to prove then rests on the person with the PCP.
Yeah. Turning now to the next question. This is a question about Windrush and the Wendy Williams report, which found that one of the problems one of the many problems that happened in that case in respect of the group of Windrush individuals was that the Home Office didn't carry out appropriate EIAs. Assuming an individual case were to be pursued, what weight would this finding have? Is there a presumption that in the absence of an EIA, discrimination cannot be justified? Alex, I'll ask you to answer that question first off.
Well, there's not a presumption, but I mean, an EIA doesn't have to be undertaken in any particular form, but obviously there is the duty to conduct a public sector equality duty compliant review of most policies. And if there's no evidence of the way in which that was done, then it does become a lot more difficult for the defendant to try and justify it. And indeed, that's a difficulty for the Secretary of State in my case that I was talking about, that they have now eventually, we in fact in earlier litigation forced them to review the policy, and they've produced a statement which says what they've taken into account. But the statement's quite deficient in terms of a number of ways in which it tries to justify the policy. So it becomes a lot more difficult for a defendant to justify if it doesn't have a suitable defence in a proper statement. But I mean, there's even a principle that you can bring ex post facto justification in. Of course, there's a less weight might be given to the court, and it doesn't help the court understand exactly what was at stake when you were formulating the policy, but it's not ruled out in terms of justification.
From a practical perspective, the reason to do an EIA, or even if you don't do a formal one, the reason to do something which looks at it is precisely to provide you with your justification defence if challenged, because that's when you should be looking at what the less onerous options or objectives might be. If we did it like this, it's going to cause that impact on this group of people, but if we did it like that, it's going to cause that impact on this group of people. So, you know, it should, if it's done, it should therefore lay the groundwork for a public body to be able to justify a claim acceptably. And if it's not done, then you have to question what's going on. Although in a number of cases, EIAs are often not done if the matter is all about people who only have protected characteristics. Often an EIA isn't done in those circumstances. practically they don't do them. David, have you got anything you'd like to say on that?
Well, two things. First of all, I would hope the reason for doing an EIA, if you're a public body, is because you want to produce good policy, and therefore you want to understand in advance how your policy is going to impact on those people you serve as a public body. And therefore, if you're going to have negative impacts, you know what they are, you assess them, you put them into the weight, and you then take the decision rather than finding out afterwards. So the purpose of an EIA and the purpose of Section 149 ought to be promote good governance and good government, though I appreciate that may be seen as somewhat an idealistic point of view. Secondly, I'm slightly cynical about the quality of an awful lot of EIAs. They do seem to be exercises designed ex post facto to justify decisions that have already been taken and to minimise the impact on anyone with a protected characteristic in any circumstance, rather than being a genuine attempt to try and inform the public body of the of what's going to happen if it brings this policy into effect, because they're always undertaken in effect after the policy decision has been taken that this is what we're going to do, and therefore they tend to be, I'm afraid, in practice, here's a set of reasons why what we have already decided to do is justified. Again, I started being idealistic. You might say that latter is a bit cynical, but that's my experience of having done a whole series of cases where there are EIAs that seem to serve the interests of the public body rather than serving the interests of people with a protected characteristic.
The last question, and I think I'm going to direct this one to Alex again, is somebody's asked about Article 14 arguments in immigration deportation cases, and asked, is it the case that there are very few Article 14 arguments in immigration deportation cases because they're inherently more difficult to succeed because of the legitimate aim hurdle?
Yes, that is part of it, definitely. In Article 14 contexts, the demands of immigration control very directly and obviously apply. So the cases I was talking about where one slips out of immigration control simply into a much wider set of effects and impacts, that's not the territory in. With deportation specifically, you're talking about removing people who've committed criminal offences, and that clearly is an area of immigration control. And so leading case in the European Court of Human Rights, and that is called BAH, B-A-H, and that gives a wide margin of appreciation to the state to balance on that side of the proportionality balance the interests of maintaining effective immigration control. So that does make discrimination arguments more difficult in that kind of context, yeah.
Okay, thank you. There's only one further question which Anna, our administrator, has asked, is could somebody restate this citation for the ESOP and the Home Office case? I'm looking at both you, Alex, and you, David, cited it. So if you could just restate that again.
I've got the mutual citation here. It's 2017 UKSC 27, and the weekly law reports is 2017 1WLR 1343. 2017 1WLR 1343.
Thank you very much.
And it's not very long.
No,
it's not a 100-page judgment. It's beautifully crisp.
Yeah.
Well, thank you both to Alex and David for what have been very interesting and illuminating talks. Thank you all for listening and participating so extensively in asking very pertinent and relevant questions. We thank you all very much and have a lovely summer. Thank you. Bye-bye.